From reading the torture papers, you can't help but get the sense that these are the product of lawyers that are too smart for their own good. Don't you? So, you know, it surprised some of my friends. You know, they call when these memoranda are leaked in 2004, and they know I'm teaching at the Army's JAG school, and they're saying, "So why weren't you talking about this sooner? Why didn't you leak them?" And I'm like, because I never saw them. Honestly, I saw them when the world saw them. Here I am teaching, you know, the law of war to the Army's judge advocates, and I'd never heard of these things until I got them off the internet. I remember being really nervous about printing them off because they still said top secret all over them. And you know, at that point, 13 years in the Army, you really become nervous about this stuff. And appropriately enough, the Marine on the staff, we had one Marine instructor, his instructions from the Marine Corps were to shred any copies that he had downloaded because they were still top secret. They're all over the internet, but they're still top secret, and he can't have them. So he wasn't allowed to have them for a while, and I let him peek at mine. So at any rate, you know, we didn't get these things till much later. But when you're absorbing them, you know, you're initiated to the law of war, and I was initiated in these traditions. I considered myself by that point part of the specialized branch of the executive branch that had the luxury of learning only about the law of war. My primary duty was to teach one convention of the 1949 Geneva Conventions. Mine was the fourth. I've come to love the fourth convention. I think it didn't. I get some smiles from some people who have endured my instruction in the fourth convention. I think we've got several in the back as well. But that was my convention. But, you know, when I'm reading through these, I'm thinking, you know, these are terrible. These are not what I know about the law of war. They are unwise, but you know, they're really, some of them are colorable. Honestly, some of these, if you really look at the text, if you look at some of the negotiating history, you can see the direction they're going. Which brings me to my bigger point, which is this opportunity I've had as teaching international law to compare how it is we do business and how we interpret law versus how some of our allies, or perhaps how civil legal systems interpret the law. When I share some opinions of the European Court of Human Rights with my classes, when I share the opinions of the Human Rights Committee on the applicability of the ICCPR, the International Covenant on Civil and Political Relations, and whether it's territorial or extraterritorial, we look at how they read these opinions, and it's clear that they're not text obsessed, that the guiding principle for legal interpretation on a number of these European courts is the principle and the spirit of the instrument that they are interpreting. And so while it may do violence to an American jurist's understanding to see an and turned into an or in the case of Article 2 of the ICCPR is generally understood by American lawyers only to apply if you have both control over the territory and you're asserting your jurisdiction over a person. These are consecutive requirements in the American understanding. Well, Europe simply doesn't see, and most of the rest of the world simply doesn't read Article 2 that way. They say that as a disjunctive and, that either having a person within one's territory or subjecting them to your jurisdiction is sufficient to activate the ICCPR. And you know, you have these lawyers that you've been grilling since they were 1Ls to look for ands when they're looking at a list of elements, and they understand consecutive versus cumulative criteria. But how well did our textual obsessions serve us here? How well did they serve these lawyers? Didn't they lose sight of the object and purpose of some of these instruments? And is there perhaps room, or at least sympathy for, a legal tradition that starts from the object and purpose of an instrument before it wades into the textual details?
David? Yeah. Just returning to the Executive Order 13440, it's a fascinating story. We don't have enough time to go into it, but I worked as an unofficial private capacity consultant to the SASC and HASC, the Senate Armed Services and House Armed Services Committee, together the Military Commissions Act, and a lot of emails going back and forth. And the Executive Order flows out of a particular provision of the Military Commissions Act. It's 6A3. of the MCA, and it says, as provided by the Constitution, by this section, the President has the authority for the U.S. to interpret the meaning and application of the Geneva Conventions and to promulgate higher standards and administrative regulations for violations of treaty obligations which are not grave breaches of the Geneva Conventions. Remember, they'd already come up with grave breaches to Common Article 3, and then it says the President shall issue interpretations described by subparagraph A by executive order published in the Federal Register. And I can remember asking the General Counsel of the SASC, I said, what the heck does that mean? And he says, well, this is a major compromise. This is a victory. That provision means that the President is going to have to issue an executive order which tells in specifics what interrogation techniques the CIA can use, but they still comply with Common Article 3 to include 3.1c. And I said, you're never going to have that happen. He says, oh yeah, this is a major victory on our part. Well, 10 months later, as Bob indicated, they published the executive order, and all it did was to reaffirm all the legal theories and findings that they had come up with thus far. And then it came up with the qualified language that Bob talked about. So the next time that I saw the SASC and HASC GCs, I looked at them and they wouldn't even look at me. They just said, it didn't work out. It didn't work out. It will work out in the next administration. I think one of the first things that will be done is probably a complete repeal of the MCA, a withdrawal of this particular executive order, and perhaps the issuance of another executive order. But the point that I want to make is what we have here is a dual system of U.S. detainee treatment standards. We've got the DOD standard that comports completely with international law because of the field manual, 222.3. And then based on the Military Commissions Act and the executive order, we have a completely distinct detainee treatment regime for unlawful enemy combatants. They're at great variances with each other, but yet they remain both U.S. standards. That's unworkable and it's unlawful. And that's going to come to an end, I would predict, in a very few months.
Just as an aside, for the last 2 or 3 months, I've been working with Will Taft and 4 other people under the auspices of one of the anti-terrorism NGOs to draft an executive order for whichever new president we had. We worked on it before the election. One of the things that I asked them to add, which they did, and at least the last draft I saw, was not just torture, but also humane treatment being the standard. And I don't know if it's going to be used, but it's got some pretty heavy people involved in it. I think it certainly will not be unhelpful to them.